then this will take forever. Are investigations effective and generally perceived to be fair? Investigations ki baat kar rahe hain, which we will discuss. Are prosecutors able to secure safe convictions? The difference between a safe conviction and a conviction. A safe conviction is when you're actually sure that the evidence isn't concocted. It's a genuine conviction where you were actually sure beyond all reasonable doubt. Is the judicial system perceived to be fair and just? Judges पे pressure होता है पाकिस्तान में नहीं होता? होता है, right? I've met a judge who himself confessed to me that there was a person who I knew was 100% innocent. I got a call and they told me to give him the death penalty and gave him the death penalty. So this is what happens in Pakistan. I don't know whether the person, hopefully this guy was a sessions judge, hopefully at appellate level it would have been but this is how easy it is to take persons life away. Okay? Is the judicial system perceived to be what is the potential for abuse of counter-terrorism laws? Huge. The level of discretion. Our laws were developed by the British to rule a colony. When you rule a colony, you have one good officer for hundred or thousands or hundreds of thousands of local population. You need to give him a lot of discretion.
Mindset बहुत different होता है.
Exactly. Serve and protect वाला जो mindset है, ठीक है, is very different from the rule and colonize वाला mindset.
The civil servants that went back from British India to the UK were not allowed back into their system immediately because they were told that you were trained to rule over India and here you are public servants.
Achha, I didn't know that.
Exactly. And most of them were recruited from Scotland and Ireland. वहाँ से गए थे वो लोग और वहाँ में वापस UK गए वो. They could not assimilate back in the system immediately. You were trained to rule a colony and here you public servants.
Absolutely.
The mindset is very different.
Absolutely. So this is what you need to see. Our laws generally give a lot of discretion to state authorities. In anywhere else, you'll see that discretion is minimized through specific wording in the statute. Okay, this is what you can do. These are the limits of what you can do or how you can do it. Over here, it's pretty broad. All right, let's move on. Do we have any questions on this? Last chance. All right. So we look at the spectrum of violence. This is just a theoretical model of where we can fit everything in, the laws that we're specifically talking about. So let's begin with the lowest level of violence. Ordinarily in society, we have ordinary crimes that take place. That is when violence is taken up by individuals. Beyond that, we have sectarian violence or terrorism. That is an escalated form from ordinary. Beyond that, we have what is a warlike situation domestically or non-international armed conflict up to so long, or what we can perhaps attribute to FATA. Right?
Where would civil war lie in this?
Civil war would also fall in this category.
And insurgencies would also...
Insurgencies, militancy would also fall within the same category. Right. It's militancy, there are different categorizations and Zainab Mustafa's IHL presentation, usme wo batate hain which ones. So if basically if the non-state actor has control over territory, it's a different form of insurgency, and if they don't have hierarchical...
hierarchy hai,
exactly.
blah, blah, blah.
And then the last category is a full all-out international war. That's the worst form of violence that you can have, right? Uske beyond, there's nothing much beyond that.
Uske baad phir space wars.
Space wars, right? But they probably also fall in that last category. So, as the intensity and nature of violence escalates, the state enhances its powers to tackle that threat. It said that with the current powers that I have, I can only deal with ordinary crime. So to deal with terrorism, I need more powers. The state needs more ability to deal with these people. Longer detention periods, longer remand period, better investigation things. So for example, terrorism, for ordinary crime, if you have to go and pick up evidence, you need witnesses. So it doesn't, so that you haven't planted it, doesn't, it's a safeguard. So a police officer, if he has to find, say, this particular wallet, which was used in a crime, he will bring elders from the village to record it and get thumbprints looking at which that this was done properly. In terrorism, you don't need to do that. 88 usually. Right? So they've changed the powers there. And so we see that as it happens. The state employs increasingly more powerful tools and mechanisms to address the problems, such as the deployment of the armed forces and civil armed forces. So the Rangers in Karachi, because they couldn't deal with it under the normal law enforcement framework, they brought in the Rangers. Do we see how we're enhancing the state's ability to deal with these things? Now, if the nature of violence intensifies to become an internal armed conflict or a non-international armed conflict, then the state shifts the legal paradigm altogether. So there's only so much it can do within the constitutional confines dealing with this. When it gets to this, it says, yeah, the state structure is failing here. Civilian institutions simply cannot deal with this. So we have to enhance the ability. You bring in the armed forces and give them their full powers over there. And that's what we see happening in Pakistan and around the world as well. So we're clear on this distinction. There's a different legal paradigm that applies. Now let's look at what the nature of these two different paradigms is. One is the conflict paradigm, the other is the peacetime or law enforcement paradigm. Okay. So fundamental features, the fundamental difference between the two is the application of human rights. These things. Human rights will not apply in a conflict, and we've looked at this also with the IHL lecture that we had. Okay? So human rights apply broadly. The aim is to capture criminals to stand trial before a judge. That is your primary aim. Bringing before a judge, due process, fair trials to them. Use of lethal force is only a means of last resort. You must first capture him. If he resists or if he shoots back at you or something like that, then and only then. Ideally, depends if you're in the US more. But it really depends on a number of factors. Pakistan, you cannot use lethal force unless if you're capturing him for an offense which carries the death penalty. So it's a little difficult. A police officer has to know, "Achha, kis cheez ke liye pakad raha hu? Achha, isne kisi ko mara, theek hai, now we can shoot him, no problem." Fire and whip type scene. Persons can only be detained without charge, preventive detention, for a limited period in accordance with human rights standards, in accordance with your constitution. All of these are different when it comes to a conflict paradigm. So in FATA, this would apply in Karachi, Balochistan, etc. In FATA, human rights may be derogated from, right? Combatants or fighters can be lawfully targeted as they may be killed at any time during the conflict unless they surrender or become hors de combat. So basically, what they're saying is, ek jagah pe peacetime paradigm mein, your job is to capture the guy, not to kill him. Once you're in a war type situation, in a conflict situation, you can straight up aim and kill that person because he's going to be doing the same. Once you gain that status of being a fighter or a combatant, a fighter can be killed at any time, whether he's sleeping, whether he's eating food, whether he's in the washroom, taking a shower, whatever. Because of that status, he can be killed. Unless he becomes injured out of the fight, he raises the yellow, the white flag, or he becomes, outside of, or surrenders, for example. When it comes to detention, a person can be detained for the duration of the conflict. And all of this we see in our laws as well. Okay? Now, we've got those heads, right? Under those heads, let's fit in the laws that we have in Pakistan. To see, now it's very easy and we've done a lot of work to put these in, but this took about 4 or 5 years of analysis to be able to understand this. It seems very simple, right? No one's done this in Pakistan. We just have laws, they've created them, but they haven't done the thinking behind it. There are very few people who actually understand, acha, this fits here, that fits there. And I'll show you what some of the problems are. You'll see that, so the fundamental distinction is this. This applies in a peacetime, this applies in conflict. Let's look at the laws here. Ordinary crimes, Pakistan Penal Code, then there'll be specific criminal legislation such as Arms Ordinance, Explosives Act, all of these. As CRPC, Qanun-e Shahadat, these generally apply here. Terrorism, because again it's in a peacetime conflict, peacetime paradigm. You have the Anti-Terrorism Act, which is a specific law that applies there. The Protection of Pakistan Act would also have applied here. Pakistan Army Act now applies. Why?
Because military courts are
military courts. Absolutely. And you have the CRPC, which applies Qanun-e Shahadat, etc.
Military courts are उनकी जो applicability होती है वो Article 45 की notification के तहत होती है या नहीं 2021 amendment की बात हुई है ना?
It's a specific amendment to the Constitution.
Right.
They're created under the Pakistan Army Act, but the authorization, because they violate human rights, they have been given a specific exemption under Article 8 of the Constitution.
Oh.
So it will be placed in the first schedule. This law, the Pakistan Army Act. Okay, now when we move into a non-international armed conflict, what do we have? Article 245, we've discussed this generally. This allows all deployment of the armed forces under 3 heads. External aggression, threat of war, or actions in aid of civil power. External aggression, anyone? What does that mean?
known from outside or not international?
Exactly. An international war. If India was to attack us, this will authorize the armed forces to defend us. Threat of war. Even I don't know what that is. But 21st Amendment, the Supreme Court gives some guidance there. And the third is action.
Threat of war, for example, like 2001-2002 escalation of the job. So there's a threat of war.
Yeah, that's what I would have thought as well. Right?
Also there's
Supreme Court said something else. Nahal ke lecture kal, I know she touched upon this point, but anyway, we'll get to that. And thirdly is actions in aid of civil power. That means domestic deployments. At least that's what we would think it would mean, right? Domestic deployment of the armed forces in aid of civil power. So to assist civilian institutions when they can't fulfill their own role because of the security situation. Then the armed forces comes in, settles the security situation, allows them to function.
And Rangers are not a part of these armed forces in that.
They're civil armed forces.
They're civil armed.
Yeah.
Paramilitary.
Exactly. So they're deployed under the Anti-Terrorism Act.
Okay.
Sir, NIC में आर्मी आती है, आर्med forces अगर पुलिस ना हो, तो कराची का जो सीन है कि रेंजर्स आ गए, तो वो NIC में नहीं है।
नहीं, वो नायक नहीं है. So you can have armed forces deployments even in a law enforcement paradigm, a peacetime paradigm. As long as the law that deals with them works under the human rights framework. The Anti-Terrorism Act is subject to the human rights. So the Supreme Court, the high courts will look at the application of all of the fundamental rights in the Constitution to the ATA as well. You see? So ये नहीं है कि ATA just because the Rangers have come in, so the rights don't apply. They still very much apply.
मिलिट्री कोर्स अगर पीस टाइम में आ रही है, आर्मी पाकिस्तान आर्मी आपके तो फिर ह्यूमन राइट्स की फेयर ट्रायल या राइट टू फेयर ट्रायल
ये मैं आपको भी समझाता हूँ. Let's just go through this. So the next is actions in aid of civil power regulations, which apply only to FATA. FATA, we're clear with that. You guys have already discussed that a little bit. Now, interestingly, यहाँ पे भी Protection of Pakistan Act है, यहाँ पे भी Protection of Pakistan Act है. यहाँ पे भी Pakistan Army Act है, यहाँ पे भी है. Why? Why is this there? Because there is a fundamental confusion in our legislature. We don't know what the types of laws that we're making or the impact that these laws will have. अब आपने if you were talking about just FATA, you could have had the Pakistan Army Act Amendment, military codes, without requiring a constitutional amendment. But because you're also applying them to any form of terrorism in Pakistan, which is religious and sectarian in nature, which is a limiting factor, they had to have a constitutional amendment, which said that human rights, fundamental rights, do not apply here. And that's why in this context, you have the same mechanism that deals with people captured from the battlefield in FATA, as well as people captured from Multan or from Deir Ismail Khan or from any other area.
Adiala level.
Anyone. I don't know what the details of the I don't know where they were picked up from. So you have the same mechanism applying to both. It's straddling both systems. That's confusing significantly. Then what you have, if you had a war with India, you would have Article 245 allowing the armed forces external aggression, Pakistan Army Act, and Geneva Conventions because it's an international transaction taking place, right? It's an international dealing. You're having war with another country. So we're clear on this?
So Geneva Conventions, Geneva Conventions would not apply for NIC, right?
They do to an extent. Article 3 is the only one that applies. All right, any other questions before we move on?
Why sometimes armed forces capture the people from all over the Pakistan and they should be to FATA and then...
Because there's a legal provision for it. There's a provision under CRPC as well as under the WACPR for it. CRPC में तो है, removing people to the tribal area. So if there is a nexus between something that this individual has done in the rest of Pakistan with activities happening in FATA.
Nexus आपने prove कर
Exactly. If you can prove that nexus, then you can transfer him there and detain him under the WACPR. Okay.
Which is like काफी vague like.
हाँ, but इस किस्म की जब चीज होती है, then the high courts can exercise jurisdiction. Article 245 का, if you guys done specifically, you looked at Article 245?
नहीं देखा है.
नहीं देखा है?
नहीं देखा.
Like in any of the lectures, right?
Specifically, I don't think हमने देखा. मैं वही निकाल के बैठ रहा हूँ अभी यार.
That's a coordination amongst my team. Well, let me see if we.
functions of armed forces, right?
Yeah, take it out.
Yeah, I've got it. 1, 2, 3, 4.
Yeah. So let me read this out quickly, okay? Yeah, but why don't I put this up?
I can do that.
Yeah, actually, let's just read it out, maybe quicker. Because I don't want to spend too much time here.
आ जाएगा 2 मिनट.
So listen, let me just do it. That's fine. That's fine. Just put it over there. So there are 4 sub-articles to this. And it reads, the armed forces shall, under the directions of the federal government, defend Pakistan against external aggression or threat of war, and subject to law, act in aid of civil power when called upon to do so. So we've got those 3 down already. The next sub-article 2 is, the validity of any direction issued by the federal government under clause 1 shall not be called in question in any court. What does this mean?
Courts don't have jurisdiction.
Exactly, this is a purely executive action. Launching or deploying the armed forces is the executive's job, not the judge's job to determine. Okay, so they made this under the constitution something which is known as non-justiciable. As in, you can't make a judicial decision on this area. You can't say, oh, ye jang jo India ke saath aapne shuru kiya sahi nahi hai. Judicial review. No judge is allowed to do that. And this happens all across the world. So they just stated this. Number 3, a high court shall not exercise any jurisdiction under Article 199 in relation to any area in which the armed forces of Pakistan are for the time being acting in aid of civil power in pursuance of Article 245. What does this mean?
Fundamental rights.
199 is how you enforce fundamental rights, right? Jurisdiction, judicial review, all of these things. So that mechanism has been disengaged. Your mechanism to ये उन्होंने कहा कि fundamental rights खत्म हो जाती हैं. उन्होंने कहा जो enforcement का mechanism है rights का वो अगर नहीं apply होता. Okay? And finally, any proceeding in relation to so any proceedings will remain suspended till the action is done. So this is basically Article 245, and this deals with all deployments of the armed forces. Even technically जो आपके Anti-Terrorism Act के नीचे armed forces को आप deploy कर सकते हैं, वो भी 245 का कहते हैं. So there are 2 ways of invoking 245. One is directly. When you directly invoke it, all of 245 applies. 199 engage hota, your fundamental rights remain suspended technically, you can't call it into question, all of those things. But if you do it through an act, for example the Anti-Terrorism Act, or the CRPC, you can get the dispersal of unlawful assemblies there under the Criminal Procedure Code. So the armed forces can be called in case if a riot is taking place, you can use force to disperse it. So
you can limit the clauses which have been.
Yeah, so when it's invoked through a law, because the law itself operates within the fundamental rights framework, उस situation में फिर 199 apply होगा. You will be able to enforce fundamental rights against the armed forces. So Rangers का उन्हें जो एक बंदे को मार दिया था, गोली मार दी थी, and he bled to death there. He was a criminal himself, but they exercised, these people were sentenced and punished for that, Rangers officers. Right? So that's a fundamental difference. Okay, so now we went to
What about 184.3 Supreme Court jurisdiction for judicial review?
That's pretty much the same. But generally what they've said here is they've limited. The reason why FATA can't go there is because Supreme Court and High Court jurisdiction is limited not to, it doesn't extend to FATA. You see? That's why it doesn't really matter. FATA के लिए ये generally Pakistan में नहीं apply होता और वो नहीं apply करते. Judicial review और ये सब. In fact, I'll give you an interesting incident. ये जब धरने हो रहे थे इमरान खान के. So Chaudhary Nisar and these people decided to impose Article 245 when the Rangers in. They directly invoked it. So when you directly invoke it, my High Court, I think it was Minalla and these judges who said, I can't take any more cases under 199 because Article 245 now is over. So then the Attorney General and these people came and said, no, what we meant was you can't have cases only in relation to armed forces in Muslim. But technically, if you look at the language, it's pretty wide. You can't accept any 199 related cases. Alright, so let's quickly go through the Anti-Terrorism Act. So this was amended 19 times since 1997. अभी इस साल भी एक amendment इसमें आई है. So I think ये 19 या 20 2017 की lynching has been added. That's a terrorist offense. Exactly. There's 5 E's वाले new sections. 11 triple E, triple E.
My problem with this is the whole thing is like a reactive piece of legislature. ये हम लोग lynching का पहले नहीं सोच सकते जो डाल रहे होते हैं.
Hopefully I have the definition up here, but I'll explain this all in detail. So I spent a lot of time on the definition of terrorism and on how that is the biggest problem that we have. We'll go through that in a bit. Absolutely. So it's a reactive thing, and it's not even a good reactive thing. So it's been amended 19 times. 2014 May. This first one was the one that we worked on, and we brought about changes in the anti-terrorism. And this was relating to shoot-to-kill powers and witness protection standards, pre-trial scrutiny of a case, all of these things. The context, as we mentioned, was sectarian violence, political violence, etc. Okay? So as it was originally established, just a quick summary, it established ATCs, anti-terrorism courts, with expedited procedures and lower evidentiary thresholds. It was easier to convict and faster to convict in these ATC courts. It extended the aid of the military to civilian institutions or authorities. So ये actions in civil power. इसके नीचे भी आप deploy कर सकते थे. It permitted arrests and searches without warrant. So there are some offences for which the police or the armed forces can arrest without warrant. And offences were non-bailable and non-compoundable. What is compoundable? Compromise हो सकता है. You can meet with the family of the victim and say, I'll give you this much money, you got money, all of these things. There were wide indemnities to law enforcement personnel. So they had a lot of protection for actions that they undertook under this act in their lawful execution of their duties. It allowed for the banning of organizations, जिसको prescription भी हम कहते हैं. And there were shoot-to-kill powers against, now this is the original language, against person who, in his opinion, in all probability is likely to commit a terrorist act or any scheduled offense, you could shoot and kill him. If you thought that he might be likely to commit, in all probability. And then there was special ATCs, which case could not be appealed to a normal court. They had a special appellate tribunal. This is what happened then. Mehrabali happened to them. And major provisions of the ATA were challenged in this case. The Supreme Court ruled on the following points. Shoot-to-kill powers were invalid. Those ones that I just mentioned. Mehrabali mein, what happened in Mehrabali?
Sectarian violence.
Sectarian violence. Mehrabali was sectarian violence case, so was Liaquat Ali. That was the next one that we look at.
It was a bombing in Lahore, which around 70 people died in 1996, 1997. So the perpetrator was, Sayyid Mehrabali case. So the ATA was used in this case.
Okay.
The newly enacted ATA, the ATA was drafted in response to this incident, and then it was challenged in this case.
So the defendants which are Mehrabali to defend,
I don't know if Mehrabali was the defendant or not, but Mehrabali was the challenging of this case as well.
Right. Thank you.
Okay, so then we had warrantless searches be conducted only after the officer concerned is reduced in writing his reasons for the search or his suspicions. Trials in absentia under the ATA were invalid, as in the person had to be there. Appeals from ATCs would have to be to the High Court, not to these special appellate tribunals. That ATC judges should have fixed and established tenures. The government shouldn't be able to post whoever they want, whenever they want, and remove them. So security, independence of the judiciary is also important, so they could give independent judgments. And confessions before Deputy Superintendent of Police were not admissible. And this is generally the case. There has to be some corroborating standard. Magistrate somehow. So Liaquat Hussain, the next following year, we had another decision on this. The Supreme Court issued detailed guidelines on how ATC trials should be run. They should be done on a case, one case at a time, on a day-to-day basis. All right. Defective investigations should lead to the investigating officer being punished with disciplinary action against him. And that the armed forces, by virtue of Article 245 of the Constitution, could be tasked with ensuring the security of judges, advocates, and witnesses, but could not play an adjudicative role. What does that mean?
Right. For example, the judges and whoever, like advocate, they will be protected by the armed forces, but the armed forces cannot take part in trial.
Because during the same time, the specifically for Karachi, we had these hybrid tribunals established, where there was a civilian and a military judge. Okay. And they immediately, in this case, said no civilian could be tried in military courts and transferred all the cases that went to those courts to the ADCs. Why is this important? Because military courts जो अभी established हुए वो किस basis पे? यहाँ पे military courts को clear cut लियाकत हुसैन में कहते था कि when you are acting in aid of civil power, you are in aid, you are supporting them. You can't usurp their function. You can't take over their role. The judiciary is a civilian institution. The armed forces can provide security to them, can help them, but can't play the role of a judge. Now this is what the 21st Amendment case में the judiciary had to backtrack from, because इसमें Supreme Court ने कह दिया था कि कभी भी कोई civilian जो है military court के सामने try नहीं हो सकता.
But can't you make an argument that if there is like a military judge as well as a civilian judge, that military judge is going to add towards like
उसमें वो involvement of the military is the issue there. That becomes an issue there.
Maybe issue of independence of judiciary.
Absolutely. Alright, so as we mentioned, the biggest problem with the definition of terrorism. Now, initially, जब ये नया आया था 97 में, there was a 2-paragraph definition of terrorism. Very basic. 2000 में ये amend हुआ, they took the UK definition and just copy-pasted it, literally copy-pasted it there. Still a very good definition. उस वक्त से जो 19 दफा amend हुआ है, 2 paragraph की definition is now over 2.5-3 pages. ठीक है? And it is superfluous language, most of it, unnecessary language. For example, killing someone is terrorism if you fulfill the other requirements. Killing a media person is terrorism. Oh यार, he's also a person, खुदा के बंदे. Government official वो इंसान नहीं है. ठीक है, उसकी specifically आपने category बनानी है नहीं. It's clear cut. But कोई कहीं पे कोई incident हो जाता था, कोई journalist was killed by terrorists, तो उन्होंने कहा, oh, just to relieve the political pressure, हम amend कर देते हैं ये.
And then the Quran आके बोले कि हमने बकायदगी डाल दी है इसके.
Exactly. So okay, so let's look at and understand legally and theoretically what terrorism and how it's defined in the law. Zainab Mustafa covered the definition of terrorism.
Yes.
No.
No, we're going to. Yeah.
Okay, let's quickly do it. So all offences carry 2 elements. Anyone who's a law student knows this. Okay? So there's the actus reus, there's the menus reus. The actus reus is the physical act. So if I stab someone, up. But you're right, you're absolutely right. So there is the physical element, me stabbing someone, so the act of stabbing. Now it could be that somebody pushed me and I happened to be holding a knife and fell on that person. Did I have the mental, the criminal intent to kill this person?
Act and intent.
Exactly. Right? So I did not have that mental element. So I'm not guilty. Only if these 2 things are there are you guilty of an offense. Terrorism is a superior category. The mens rea requirement, the mental requirement, intent requirement is higher. And that is, it requires a 3rd element, which is the motivation or purpose or design. So not only do I want to put this bomb here, not only do I have the intention of killing all these wonderful people here, but I also want to do it to promote my ideology, my Al-Qaeda or my ISIS ideology. Okay? That is what terrorism is. Otherwise, it's an ordinary murder. I just wanted to kill a few people. Right? So it's this additional thing which allows for all these special, exceptional things, because what terrorism does is, it undermines the state's rate at a level that ordinary crimes don't.
Right.
So because it is this special, unique form of violence, the state says we need to deal with it really well. Because any person, usually terrorism is innocents are killed, right? Just to spread terror. So the impact is these people are killed, but it's the impact that really helps this terrorist organization. लोगों के अंदर खौफ और हरास फैलाना. Okay, and that is why terrorism has to be dealt with by these special laws. So the exceptional nature of terrorism is what allows these exceptional laws to apply to it. Pakistan में क्या हुआ? They messed this thing up a little bit. They have diluted this 3rd element. They've said कि अगर actus rea है और mens rea है basic जो है, everybody knows कि हर act से खौफ और हरास फैलता है. ठीक है? So what we're going to do is we're not going to require this thing if fear and panic and all of these things have been spread with that an ideology or a motivation or purpose is there. So we've diluted that. And that's what, and it's not just been done by the law, but it's also been done by the judicial interpretation. So because our judiciary do not have very good understanding of how terrorism applies, they have unfortunately looked at it and in successive decisions had two different approaches to it. एक में वो ऑफेंस देखते थे, बहुत लोग जख्मी हुए हैं, लोगों को डर लगे बस टेररिज्म। दूसरे में उन्होंने कहा